Now, if Nandipha Magudumana has problems with her deportation, she'll have to take it up with Tanzanian authorities. That's according to Judge Philip Loopster. Magudumana brought an urgent application seeking to declare her arrest unlawful. The application has been dismissed with cost. Let's go to eNCA's senior reporter, Silindelo Masikane, who is at the Bloemfontein High Court for us. She joins us now live for more details. Slee, what have other experts told you she could do? What kind of legal avenues she could pursue if she wants to take this further?
Well, at this stage, we do know her lawyers have made their way to the Kroonstad prison where she is being held to get instructions on the way forward. She may have a few options available to her. Of course, one of them is an appeal. Whether it's going to be in this court or a higher court, I think remains to be seen. And whether or not she will be appealing this particular judgment that, of course, is not in her favor, but in many ways she has been vindicated in what she was telling the court about her deportation being in fact an extradition. But to unpack that judgment for us, I'm joined by somebody who knows a little bit more about the law than I do. That is legal expert Mr. Alton Hart from the UJ Law Clinic. Thank you so much for your time this afternoon. We spoke this morning just around 7 a.m. where in fact you were already telling me that Dr. Nandipha, there are some merits in terms of the case that she was bringing before the High Court. Now, we know, of course, that the judge did feel, while it wasn't urgent, the interests of justice permitted for him to be able to enroll the matter. Let's just talk then about what was said in that judgment. It does seem as though the judge really agrees that Dr. Nandipha was extradited. The only issue is that it seems she consented to returning to South Africa.
Indeed, so if one looks at the fact findings that the judge made in his ruling, it seems that the judge found in favor of her on facts that she presented to court to say, listen here, I was removed. This was a disguised extradition as a deportation. So the court said what you are saying to us is it's correct, that you were actually extradited and they did not follow the procedures. Although the court said she can actually go to Tanzania and fight it off there, but obviously the issue still lies in that she was removed unlawfully so that removal, that's where the court needed to focus. And I think I disagree with the judgment that the application was supposed to be dismissed. In actual making that fact findings against the NPA, the police, as well as the Department of Home Affairs, the court then had to give her or the application in her favor, and that's how I see it. People might differ from me, but that's how I see it, because you make all these fact findings that what she presented to court is right, and you go on and say that she consented. That was on a version that was placed before court by Home Affairs. She disputed that version, yet the court accepted that she consented. She actually went in her replying paper saying that she was never even given an option to choose, and it seems that there, for me, the judge overlooked where she said in her replying affidavit, and I think at the back of the head of the judge, he was lingering on to her bringing new things, what the minister said in the media about certain things. And again, today, it was just confirmed by the Minister of Home Affairs that they knew before the 12th of April already that she's going to be declared a prohibited immigrant. So that collusion is there. So for me, I think, I'm not saying that the judge now sort of favored the state, but I think most probably he read the law in a different way than from what I read it. And I feel that that application would have been and should have been successful for her. Although her victory would have been short-lived, but she was supposed to get victory today in that application. And appeal is on the cards, I think.
So certainly it does seem like there are grounds for an appeal, and it does seem as though that it's a victory on principle. But a lot of speculation around the fact that Dr. Nandipha brings this kind of an application to, in essence, try and avoid those legal proceedings in the magistrate's court. Is this then not an abuse of the legal process?
I would not see it as an abuse of the legal process. It's a right that exists there for her to utilize. So every person has the right to be presumed innocent until proven guilty. And then there's legal avenues that a person can follow. And she's following one of them, and she says, listen here, how I was brought here was not in terms of the international law standards, the SADC protocol, and the applicable laws in our country as well in the Tanzanian country. So she says, just comply with the law and make sure that my rights is not violated, which is in the constitution. So it's not an abuse of process. She uses what they have also used. They've used a disguised extradition in the form of a deportation to bring her back. They were using laws and making it work and fit for their purposes and needs. She's doing the very same. So people should not say that she's abusing. She's using what machinery the system offers her, and there's nothing wrong in doing so.
Then let's talk about whether this ruling will have any material effect on the proceedings in the magistrates' court.
Obviously, the ruling now, as it stands, it means that she should now stand trial, either bring a bail application, but if she brings a bail application now, it might be used by the prosecuting authority to say, listen here, she already brought an application to declare her arrest and detention unlawful. So it makes it a little bit more complicated for her to prove that she might be standing trial, and it might play into the interest of justice, although it was important for both parties, be it applicants and respondents, for this case to be heard. And it would have meant most probably that they would have to start charges afresh against her. But for now, as it stands, it means that she has to now subject herself to the proceedings in the magistrate's court, be it that she brings a bail application or they set the matter down, and I think this matter would most probably proceed in the High Court, where the trial, it won't be in the regional court because of the high profile nature of this case. So she needs to set her sight now on that, given that she still has the option of appeal. If she takes it on appeal and maybe she's successful that side, then we're back to square one, that they have to now maybe charge her again if she's still in the country, or if whatever the court says needs to be done with her. But it will be also if they say it's unlawful, it will be short-lived victories, because she still has to, the charges won't disappear by this. I don't think that the court will say that the charges should disappear.
Yeah. Lastly then, Mr. Hart, let's touch on whether or not, in terms of, legal proceedings we could see after this process in the criminal courts, would then she have the option to sue the state based on what was said in this judgment?
Now, when one looks at this judgment, because the application was dismissed, they might say there was fact findings made that she was sort of half extradited without being through the correct processes, and obviously the court rejected that. She actually instructed somebody in Tanzania to actually represent her, because the immigration laws of Tanzania makes provision for that. We need to now get to a point, or she needs to get to a point, where maybe the High Court says they're going to now rescind the order that was granted by Judge Lobster in the High Court and replace it with a different judgment in her favor. Then obviously that opens the door for her to actually civilly sue the state for that period from, I think, 12 April midnight till today, or whenever that court makes that finding, to say that during that period she was unlawfully detained. But for now, it seems that her detention was lawful as per the judgment handed down by Judge Lobster in the High Court of Bloemfontein.
Do you think then this is an indictment on the behavior or the conduct of South African officials in Tanzania?
No, obviously this leaves a lot to be desired by how the South African officials handled themselves during this entire process, and it actually showed that they have flouted a lot of international law principles, as well as our own legal principles in our country, because it showed that they sort of have used shortcuts to actually get, yes, we want people to stand trial, yes, we want people to answer for their trials in the trial courts, but the rule of law is still the rule of law. We cannot make different rules for different people. The rules must be applied equally to everybody. So if we say we want to deport, then it must be Tanzania who's deporting, and not us playing an active role and colluding, if one can use that word loosely, with authorities. We should follow the procedures. We should apply the rule of law, and we do have a constitution in this country. And sometimes it seems like people just want to use and make and break with the constitution when it suits and fits them, and that's not supposed to happen.
Thank you so much for your time this afternoon. That is legal expert from the UJ Law Clinic, Mr. Alton Hart, unpacking that judgment for us in terms of that application, of course, being dismissed with costs.
All right. Senior reporter Silindelo Masikane in Bloemfontein for us.